Welcome to 60 Second Civics from the Center for Civic Education. I'm Mark Gage. The Eighth Amendment to the Constitution is the shortest amendment in the Bill of Rights, and it is fairly straightforward. It reads, "Excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted." This limits the government's power to punish criminal defendants and those convicted of criminal offenses. The English Bill of Rights prohibited cruel and unusual punishments, using those words exactly, as did many state constitutions and the Virginia Declaration of Rights of 1776. But what exactly constitutes a cruel and unusual punishment? The courts have wrestled with this question since the Bill of Rights was ratified in 1791. America's founders were well aware of the many instances of punishments that, by their standards and ours today, would have been considered cruel and unusual, such as drawing and quartering a convicted criminal, starving them, or burning them alive. Other punishments practiced in the colonies might be considered cruel and unusual today, but not in the 18th century, such as cutting off a person's ears or hanging as a penalty for theft. The Eighth Amendment is normally interpreted as expressly prohibiting torture, but it does not prohibit the death penalty except for those under 18. However, the Supreme Court has held that punishments that are disproportionate to the offense are prohibited. The 1958 Supreme Court decision, Tro v. Dulles, held that instead of defining cruel and unusual punishment as it was understood when it was drafted in 1789, the amendment should be interpreted using the evolving standards of decency that mark the progress of a maturing society. Nevertheless, debate continues to revolve around the interpretation of the meaning of cruel and unusual, and in particular, whether this standard should rule out the death penalty in all cases. That's all for today's podcast, 60 Second Civics, where civic education only takes a minute.